Hello, so today I'm going to do a presentation about chapter 8, which talk about constitutions and constitutional design. I have 3 parts in my presentation. The first is about concepts, the second one is about the types of constitutions, and then the last one discusses the cause and effects of the federal constitutions. Let's start with the first part on the concepts. So first of all, what are constitutions? Constitutions are fundamental and supreme laws of modern states. They take the form of a specific legal document, usually written in a charter, and their main job is to establish the basis of a political system and the basis for other laws. Now, what are the key functions of constitutions? So I wrote 6 of them. The first one is to elaborate the structure of the government. The second one is to establish the set of rules and norms on which society relies on. Therefore, constitutions can be seen as a set of laws outlining the basic structure of the state and its patterns of governance. The third function of constitutions are to express the founding principles, the values of society. It can be unity, equality, anything, and the aspirations of the people, and they vary place to place. The fourth function is that constitutions create a design for a country for more political institutions, so that includes legislative, executive, and judicial branches. The fifth function is to address the division of power between a central government and the provinces. And the sixth function is to establish a very important power of constitutional interpretation. So that's related to the judicial review that we're going to talk about later. Then, what form constitutions take? So, constitutions are written documents passed by some sort of constitutional conventions or assemblies that brings together many of the country's dominant political leaders and figures. Constitutions may be short or long, but is often very dense in bureaucratic prose. And in most cases, constitutions are written down in a single document that is subjected to change by a process of amendment. When this process occurs, so it can occur at the founding of a country, and it can also occur as a part of a very long transitions to full judicial independence. Now, what are the goals of constitutions, which refers to this idea of social contracts? So basically, this idea is that in exchange for the establishment of order and rule of law, society establishes a social contract in which the people confer authority on political actors. This may be a problem for minorities because they might feel excluded from that process. One feature of constitutions, and it's an important one, and it needs to be mentioned, historically constitutions are linked to the idea of constitutionalism, which basically means limited government. So now we established the entire concept on constitutions, we're going to talk about this idea that constitutions might include certain groups within society and they might exclude others. So first of all, what is the definition of constitutional design, which refers to that questions? Constitutional design refers to the features of the constitutions that shape the powers of different political institutions. And these features vary. So, constitutional design also are important because it gives countries the chance to set up effective institutions, which is really important. So which groups are included and which are excluded? So, for example, if we take the Canadian example, the groups that are included are, for example, what we call the Anglo-American Union or the majority of the settler population. On the opposite, the groups that are excluded in the constitutions are usually minorities, which include indigenous people or racialized groups, who are usually in a permanent state of exploitation. Now we're going to talk about a really important part of constitutions. It's the separation of power. So basically, there is two parts here. There is the federalism and unitarism. Federalism is a political system in which multiple levels of governments have some degree of autonomy in the same territory. This system is often developed in very large, very populous countries, where it will be very difficult to administer all policies and social programs for a central capital. Federal systems are really important, and also because, like, in some countries, subnational governments such as like provinces, territories, state, regions have constitutional protection or authority and guarantee of autonomy from the central government. An example of that will be Canada and its 10 provinces. And on the opposite of federalism, we have unitarism, which refers to the absence of federalism or unitary governments. But what basically does that mean? So here, the institutions and the branches of the central government effectively wield political power. In the world, most countries are unitary. And in these countries, local governments have some authority to shape the local rules, but the laws made by these local governments are subjected to the central authority. This constitutional design involves the establishment of the separation of power among different branches. There is 3 different branches, but before talking about those branches, I want to give the definition of the separation of power. So the separation of power refers to the division of powers in a government system between branches of governments or between levels of governments. So what are those branches? There is 3 branches. There is the legislative branch, there is the executive branch, and there is the judicial branch. So the legislative branch is responsible for formulating and passing laws. That basically is the job of parliament, congress, or assembly. The executive branch is a portion of the government that is usually elected, and the powers and function of this executive branch are outlined in the Constitution. The last branch is the judicial branch, which is responsible for the interpretation of laws in court. Now we're going to talk about the second part of this presentation, which is the types of constitutions. And the first thing to consider is that states may be flexible or rigid when they are talking about like changing the constitutions. So states that are more flexible to constitutional change is basically this idea that constitutions may be changed by a simple majority of the legislature, and then the states that are more rigid about the constitutional change are the constitutions that may require super majorities in each chamber of the legislature, or the approval by a number of units of the federation to make a change in the constitutions. Now we're going to talk about the degree of federalism in constitutions, which is basically about a separation of power and this judicial review and parliamentary sovereignty ideas. So concretely, this has to do with the degree to which courts have the power to decide constitutional issues and rule on whether a law passed is constitutional. So there is 2 types of courts. There is the constitutional courts and the local courts. Constitutional courts are courts that may strike the law, or courts are separated from the civil and criminal court systems, and they basically are reserved for major constitutional issues about whether a law passed by the government is valid. The second type of courts are the local courts, and they are for local disputes. They involve local laws that includes arrangement over property or issues of like marriage, divorce, for example. Then we're going to talk about an important concept, which is the judicial review. So this is the process by which national courts examine the constitutionality of law. It is a central idea of political power, and judicial review generally operates with a Supreme Court that serve as the final arbiter for constitutional law. Basically, that could refer to the US Supreme Court. And what about countries with no judicial review? So there are the ones where the constitutionality of law is determined by the parliament. An example of that will be the United Kingdom. Basically, the judicial system is composed of courts that rule on the merits of specific cases with the laws that exist without questioning the legitimacy of these laws. What is the definition of parliamentary sovereignty, which is related to this idea? It is basically a system in which the constitutionality of law passed by legislature and executive are not subjective to constitutional interpretation by judiciary. Now we're going to talk about the fact that even if both democratic and authoritarian regimes have constitutions, they may differ or be similar. So for example, democratic constitutions basically, their historical goal is to eliminate the absolute power of monarchs. And they do that by creating constitutions. However, not all constitutions exhibit the characteristics of democracy and limited governments. For example, in the past, in some countries, the power once held by monarchs was later held by capitalist elites, which not always represented the people. Consequently, rights established by the constitution were restricted to a small part of the population, such as these capitalist elites. Today, not all political systems are perfectly constitutional. Basic laws and rights are written on paper, but in reality, they might not be respected. Now, what about authoritarian constitutions? So authoritarian regimes usually have constitutions, even where they deny political rights and civil liberties to their people. There is other reasons, but we don't have the time to talk about them, but there was one example. Then we're going to enter in the last part of this presentation, which is about the cause and effect of the federal constitutions. So first, are federal constitutions good for social stability? Well, yes, they can promote, federalism can promote stability. As it may give people a stake to participate in the political system. As people gain more autonomy, they might just be more willing to participate in politics, but that can also undermine their stability because federalism, by drawing significant lines between different groups, federal system may end up encouraging different regions of countries to develop independent identities. An example of that will be the Canadian government and versus like the Quebec sovereigntist. Now, are federal constitutions good for democratic rights? Well, the state right perspective reflects the different set of values and beliefs of the majority in each place. The structure will allow different parts of a federal country to express their own views on rights and will be consistent with some advantage of federalism. So federalism also may reinforce divisions when allowing divergent political groups expressing their position on certain issues. Then what about the fact that federal constitutions are good or bad for the economy and society? Well, federalism may be good for economy and society because federalism generates healthy competitions among states and regions, which can be good for the economy, but it can also be bad because provinces may perform differently from one another, which may lead to a significant difference in development and opportunities within a federal country. An example of that will be India. Then the last debate is the judicial review and democracy. So debates about the judicial system is basically over judicial activism. But what is judicial activism? Well, it's a term usually pejorative that is used to characterize judicial actions that actively reinterpret legislation and thus imply exercising powers typically reserved for the legislative branch. For some judicial review, it's crucial to protect rights thanks to the law. And this argument basically refers to this idea that judges have the role of interpreting laws and to ensure compliance with the constitutions, but sometimes they don't do it the right way. One argument against the judicial review is that judiciaries remove contentious issues from the public era. So just that means that judicial review might not allow debates to take place because it's only certain groups of people that can debate about those issues. I invite you guys to talk about the case study in this chapter, which is the similarity between the Brazilian and South African constitutions, which is a good example to talk about constitutions and all the issues related to that. And then the final conclusion. So basically this chapter examines constitutions, the question of whether and how they separate power between levels of governments and whether they are interpreted by judiciary. The issues related to constitutions and constitutional interpretation matter because constitutions establish many of the formal organizational features of the state and thus are keys to understand politics. The three questions that I'm going to ask are the following. So first of all, do you think that constitutions are necessary to protect citizens' rights? Second, do you believe in the separation of power? And then, do you think that the judicial review does matter when it comes to protecting citizens?